This is Bloomberg Law with June Grasso from Bloomberg Radio.
It's a historic day, the first criminal trial of a former president of the United States. Donald Trump is accused of trying to corrupt the 2016 presidential election by falsifying business records to cover up a hush money payment. In opening statements, prosecutor Michael Colangelo called it election fraud, pure and simple. Quote, "This was a planned, long-running conspiracy to influence the 2016 election, to help Donald Trump get elected through illegal expenditures to silence people who had something bad to say about his behavior." But outside the courthouse, Trump said it was a case about a payment to a lawyer that was listed as a legal expense.
What else would you call it? Actually, nobody's been able to say what you're supposed to call it. If a lawyer puts in a bill or an invoice and you pay the bill and in the book, it's a little line. That's a very small little line. I don't know if you could even write more than 2 words. It's not like you can tell a life story. They marked it down to a legal expense. This is what I got indicted over.
In the defense opening statements, Trump's lawyer Todd Blanche said the former president did not commit any crimes and is a victim of overreaching by prosecutors who put their faith in porn star Stormy Daniels and attorney Michael Cohen. He said Cohen was disbarred, a convicted felon, and a convicted perjurer who could not be believed. Joining me from the courthouse in Lower Manhattan is Patricia Hurtado, Bloomberg legal reporter. Patty, Alvin Bragg has been the subject of many a complaint from Trump. He didn't give the opening statement, but was he in the courtroom?
Alvin Bragg, the Manhattan DA, is sitting in the front row right behind his trial team, and he listened intently as it was a prosecutor named Matthew Colangelo that used to work at the Justice Department and also worked for the New York Attorney General when they brought civil suits against the Trump Corporation back in the Trump university days. He was part of that case, and he's now the prosecutor that gave the opening statement.
Give us the highlights of Colangelo's opening statement and whether it was dramatic or subdued or somewhere in between.
Well, it was pretty dramatic. It's because the jurors are hearing for the first time, and we've heard about this hush money case. But what he was saying was that there was an agreement, a secret agreement between Donald Trump, David Pecker, who is a publisher and CEO and chairman of the National Enquirer's owner company called the American Media Incorporated. So the two of them met with Michael Cohen in a secret agreement to make sure that they would kill and catch, bury any salacious news against Donald Trump to help his campaign chances, and also attack and publish negative stories about his adversaries and his opponents for election, including Ben Carson and Ted Cruz. And they were promoting negative stories about Ted Cruz, for example, claiming that his father was involved in the assassination of JFK. So there was a story about a Trump doorman who claimed that Trump had had a love child, and they bought his silence off so that he would never tell his story. And then in 2016, in October 2016, a month before the election, the Access Hollywood tape comes out in which Trump is caught on a hot mic discussing his conquest of women. And that tape had a quote-unquote immediate and explosive impact on the campaign. They knew it was damaging, not only because Trump bragged about sexual assault, but it was in his own words and in his own voice, Colangelo said. So then what happens is they decide to buy off any other salacious news. And National Enquirer knew about this other woman named Stormy Daniels, an adult film actress, who said she'd had a sexual encounter with Trump in 2006. So they reacted very quickly to pay her off. The DA says they have emails and text messages as well as a recording of Trump discussing this payoff to Stormy Daniels with Michael Cohen, and that Michael Cohen decided to record it. So they have Trump in his own words on this recording, which can support and corroborate Michael Cohen's account.
Did we know that before?
We knew that there was a recording, but we didn't know this level of detail of all these emails and text messages going back and forth between the parties. And Colangelo said that Trump was reluctant to reimburse Pecker, and Pecker was concerned about not getting his money back if he paid Stormy off. So Michael Cohen took it upon himself to take a home equity line of credit and walked over the money and wrote his own personal check paying off Stormy Daniels $130,000. That's in 2016, right before Trump gets elected. And then Trump wins the election and then is caught on tape discussing again, does he have to really pay now that he's won? So then Michael Cohen later gets reimbursed by Trump. Then false records are created to paper over these hush money payments, calling them legal fees.
Prosecutors often, very often, have to present witnesses that are tarnished in different ways. How did the prosecution handle the fact that their star witness, Michael Cohen, is a convicted felon?
Well, that's what they were saying. They were pointing out that, yeah, we have this guy, Michael Cohen. Yes, he's a convicted perjurer. Yes, he pled guilty to felonies, federal felonies of campaign finance. But he did it at Trump's behest. And he was saying that, none of these witnesses are pure. But he also said that they had a trove of evidence supporting papers and text, documentation, bank records, you name it, that support what Michael Cohen says, where the parties who are part of this discussion and part of this, it's not a scheme because, of course, Donald Trump's not charged with any conspiracy, but this agreement that there was evidence, a trove of evidence that would support what Michael Cohen and what Stormy Daniels say.
Did it come across that this was more than just, what the defense is going to say, accounting, that this was a conspiracy and election interference?
The prosecution calls it election interference, but the defense lawyer, Todd Blanche, said there's no crime here. Entering into non-disclosure agreements is not against the law. And he says that Stormy Daniels' testimony will be, quote unquote, salacious. It does not matter. He's telling the jury, you can't base your verdict on a man who's so unreliable, claiming that Michael Cohen, who is, quote unquote, obsessed with Donald Trump and has made it his vendetta and his career, and he's pinned his financial future on making sure Donald Trump gets convicted and also going after and harassing Donald Trump. So he's saying you can't trust a guy like that.
Was Michael Cohen the focus of the defense, that he's just unbelievable?
Well, the same thing with Stormy, that she's not credible, that neither of these two people, basically Stormy was depicted as that she tried to, quote unquote, extort money from Donald Trump, and that she was trying to embarrass him and hurt his brand, and that there's nothing wrong with what Trump did, and that he claimed that news organizations and publications buy stories all the time. And then folded into that, David Pecker, the man who was part of this Trump Tower meeting in 2015, and they launched this catch and kill scheme, he gets on the stand and he said that part of their business model was what he called, quote unquote, checkbook journalism.
And I suspect we're going to hear a lot more of that when he retakes the witness stand tomorrow. As far as the defense opening, how convincing was it on the subject of this is much ado about nothing? At one point, Bland said, it's just 34 pieces of paper.
Yeah, I mean, it was effective. At some point, like I said, he said that Stormy Daniels was trying to, quote unquote, almost extort, end quote, money from Trump. And the prosecutor leapt up and said objection, and the judge struck it from the record. He was trying to basically hint to the jury and telegraph to them, look, these people are not credible, and why would you believe their word? And he actually also said, spoiler alert, there's nothing wrong with trying to influence an election. And I don't know how the jury's going to feel about that. I mean, we'll have to see if a Manhattan jury is going to agree with the defense lawyer that there's nothing wrong with trying to do what Donald Trump did, that all is fair in love and war, including this.
That may be a bridge too far.
I know. That's a very bold statement to make. It depends on how the jury is going to react to that and how they'll feel.
Did the prosecution object to that?
Yes, they did. There were lots of times they leapt up and objected. I actually lost track after 3.
The first witness, David Pecker, took the stand for a brief time. What can you tell us about him?
He actually walked into the courtroom with a big smile on his face. And at first, Trump was madly scribbling something on a piece of paper. And then later on, Trump basically twisted his entire body to turn and look at Pecker and watch him intently as he testified. He was on a very, very brief time. I would say maximum 20, 22 minutes. Most of it was talking about his his background. And it was interesting to me to hear, he said that where were their offices in New York? And he said down by Peck Street, which is down like a few blocks from here. So if you think about it, we're in a courtroom in a courthouse in Lower Manhattan, and then maybe just about a half mile away on Peck Street, the National Enquirer and American Media Inc. have their offices too. So it's kind of interesting.
And he's gotten immunity from prosecution, right? And he's the first witness because he's going to set up the whole scheme?
Yeah, I mean, he seems like he's a good composite witness. I mean, he testified before the grand jury, and when you do that, you get immunity. So he's testifying with a grant of immunity, and he can lay out the scheme in a way that maybe somebody that was allegedly tainted, the way some may view Michael Cohen as being tainted and conflicted because of his background and his convictions, might be seen. So Pecker doesn't have that kind of baggage.
Pat, this morning Judge Merchan ruled on what evidence prosecutors will be able to use in their cross-examination of Donald Trump should he take the witness stand.
Also an interesting ruling that the Judge Merchan said that the prosecutors, that if Trump takes the stand, he made a series of rulings that said there were certain things that prosecutors could question or cross-examine Trump about, including the 2 E. Jean Carroll verdicts, finding that he defamed her, as well as, and she's the New York writer that said he sexually assaulted her and then defamed her when he called her a liar. And then also can talk about the prosecutors are free to question Trump about how he was found to have violated Judge Engoron's gag order in the New York Attorney General trial. And the judge also ruled that Trump could be questioned about the verdict, the New York Attorney General's winning verdict of, $485 million he has to disgorge for unlawfully or illegally inflating his assets in a civil fraud suit.
I was surprised that the order was so broad, that the judge was allowing the prosecution so much leeway.
Yes, but they actually wanted more, including there's apparently a case involving Hillary Clinton from Florida, where the judge ripped into Donald Trump, calling him like a serial litigant, and the judge said she just thought it was too far afield.
That might affect whether Trump testifies or not, because you can just imagine the cross.
That keep things like, credibility, reliability, how do you conduct your business? Oh, wait, a state Supreme Court justice determined that you committed civil fraud.
It's
2 juries found that you defamed E. Jean Carroll. Oh, wait, a state judge found that you violated his gag order, and then when you claimed that you weren't talking about his law clerk, he found you, quote unquote, not credible. So those are the kinds of things that have a lot to say about Donald Trump's credibility.
All right, now tomorrow morning, the judge is going to hear the prosecution's motion that it made before opening statements during jury selection.
When the trial started on Monday with jury selection last Monday on the 15th, the days leading up to jury selection on the 15th, Trump had gone and tweeted or posted on social media and Truth Social a lot of comments slamming Michael Cohen and slamming Stormy Daniels and saying all kinds of critical things. And the prosecutor said that those statements were a violation of the gag order, including a third statement that they said had been made that morning the jury selection started, and they were surmising that Trump may have sent it when he was in the courthouse already. After he does that, he issues more statements. So now they have, I think, a compendium of at least 10 statements they say are a violation of the judge's prior gag order, and the most recent one was an expanded gag order on April 1st not to make critical comments of the witnesses because it could be viewed as intimidation, because Trump's followers could be, it could be sicking them on to attack them or, make comments or make their lives miserable. So the judge is going to have a hearing to determine if Trump has contemptuously violated the gag, and they're asking that he get a $1,000 fine for each of the 3 violations and a warning that if he doesn't obey, he could face jail.
I can't imagine how high the threshold would be to put him in jail, though. Thanks so much, Pat. We'll check back with you after court tomorrow. That's Bloomberg legal reporter Patricia Hurtado. Homelessness has reached record levels in this country, with more than 600,000 people experiencing homelessness on any given night. And today, for the first time in 40 years, the Supreme Court took up the topic, considering what measures cities can take to deal with the rising homelessness. Here's liberal Justice Sonia Sotomayor.
Where do we put them if every city, every village, every town lacks compassion and passes a law identical to this? Where are they supposed to sleep? Are they supposed to kill themselves not sleeping?
Grants Pass, a rural Oregon community of 40,000, has an ordinance fining people for sleeping in public places using blankets or other bedding. And the Ninth Circuit ruled that law violates the Eighth Amendment's prohibition against cruel and unjust punishment. But during the oral arguments today, many of the conservative justices suggested that judges should not be the ones to decide policy. Here are Chief Justice John Roberts and Justice Neil Gorsuch.
And it's a policy problem because the solution, of course, is to build shelter, to provide shelter for those who are otherwise harmless. But municipalities have competing priorities. I mean, what if there are lead pipes in the water? Do you build the homeless shelter or do you take care of the lead pipes? What is there isn't enough fire protection? Which one do you prioritize? Why would you think that these 9 people are the best people to judge and weigh those policy judgments?
And judges across the country are now going to superintend this under the Eighth Amendment.
Joining me is an expert in constitutional law, Harold Krent, a professor at the Chicago-Kent College of Law. Tell us about the facts here, Hal.
So Grants Pass in Oregon, like other towns, try to combat the homelessness problem in various ways. And homelessness, as we know, is unhealthy, it can breed crime, so it's not good for people who are homeless, it's not good for the city either. But the way they've done it is to potentially criminalize the act of sleeping with a blanket in a public space. And homeless advocates sued, challenging the ordinance as inconsistent with the Eighth Amendment ban on cruel and unusual punishment. And they looked to a decision of over 60 years ago called Robinson, in which the Supreme Court held that the Eighth Amendment is indeed violated for punishing what is known as a particular status. So in that case, it was the status of somebody who was a drug addict. And the court reasoned that you can punish someone for taking drugs, even if they have a compulsion, even if they're addicted, but you can't punish someone merely for having the status of being a drug addict. And as applied to this case, most people think, including the court below, that a criminal penalty for the status of being homeless is clear violation of that Supreme Court principle from years ago. And listening to the court, there was a variety of opinions that were expressed, but I think that the court is going to try to dissolve the injunction on any number of theories, but not say that it's okay to punish someone on basis of being homeless itself. There was some sympathy amongst the conservative justices and clearly amongst the liberal justices for the plight of the homeless, and that criminalizing the status is no way to solve a problem. But that leaves a number of options.
So start with the question of the necessity defense. At one point, Justice Elena Kagan just said outright, tell me about the necessity defense.
For one thing, it was interesting, the focus in the argument, which was 2.5 hours, on the necessity defense. The necessity defense is a sort of a built into most state codes of criminal law, including that of Oregon, which says that if it's a necessity to do something like tying up a ship to some private property in a storm, that one can do that and not be convicted of a criminal offense. Why? Because your preservation outweighs the importance of the property value. And so the court was experimenting with the idea. One way out is saying that Oregon's necessity defense would be an individual ticket to escape any kind of criminal sanctions if someone could prove that they had nowhere to sleep and there wasn't a bed available in a nearby shelter. So that was one way out. The Justice Department gave another way out, and said that the class action and the injunction was inappropriate because the individual situation of all of the plaintiffs had yet to be fleshed out. In other words, according to the Justice Department, individuals would have to show that they had nowhere to go before they could get relief, and the court below didn't do that. They just granted a injunction based upon the pleadings at the pleading stage in a class action. To complicate the matter, one of the three plaintiffs who had a criminal charge against her had died tragically before this case went to the Supreme Court, and so there may not be enough, according to the Justice Department, enough of a live injury about the criminal sanction to go before the court. So that was a second way out. The third way out that the court discussed was there's a new Oregon law that has yet to be administered or put into practice, which seems to ban any kind of interdiction on what seems to prevent criminalizing homelessness. And so if this law is in effect, why should the court bother to decide this case or to allow the injunction below to stand? So it's difficult to know exactly where the court's going, but they seem to think, the conservative justices, that there's something wrong with having courts administer these very complicated line-drawing policy of when sleeping outside is permitted and when it's not permitted under the Constitution. And so I think they're leaning towards a way to getting rid of the case.
And several justices seem to suggest that it was very difficult to draw those kinds of lines. Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Harold Krent of the Chicago-Kent College of Law. Was there one thing that all the justices seemed to agree on? I'm June Grasso, and you're listening to Bloomberg. Today, the Supreme Court wrestled with major questions about the growing issue of homelessness as it considered whether cities can punish people for sleeping outside when there's a lack of shelter space in the community. It's the most significant case before the High Court in decades on the issue. I've been talking to Professor Harold Krent of the Chicago-Kent College of Law. It seemed like the questions of most of the conservative justices indicated that they thought this was not a problem for the courts to decide. And the chief said at one point, why do you think these 9 people are the best to judge this? So, I mean, that seemed very clear that they didn't think that the court should be deciding policy.
No, I agree that that concern was expressed very clearly by some members of the court. And the other related issue to that is the injunction below creates a kind of nightmare for the police, because the police don't know whether someone is in an encampment have they checked to see whether there is an opening in a shelter? Have they not checked? Is there an opening in the shelter? Are they not going to the shelter because of mental illness? Are they not going to the shelter because they fear for their safety? And these kind of line-drawing issues that law enforcement officers face are very troubling and very difficult. And so there is certainly, empathy for that difficulty, which was triggered by the injunction. Nonetheless, I think the court will not disturb the precedent from 60 years ago that says that their Eighth Amendment is violated if you punish a status. So I think the court will at least my prediction is in dicta, suggest that punishing homelessness is wrong, but it's also wrong to have this injunction based upon the Eighth Amendment.
So as you mentioned, there was a lot because of that Supreme Court decision, there was a lot of talk about the difference between status and conduct. And there was all kinds of things about the difference between being a drug addict and being homeless. The Chief Justice said, a number of us, I think, are having difficulty with the distinction between status and conduct. Where do you think most of them came down on that?
I think most of the court recognized that the distinction between status and conduct gets tricky. So give an easy example from the oral argument. Yes, if you have a right to sleep outside because you're homeless, that's one thing, but then do you have a right to have cooking gear? Do you have the right to have a blanket or a tarp? Do you then have the right to urinate in public? And so on. And the conduct, in other words, is so closely linked to status that it's difficult to parse the two. And it can be done, But I think the court's position was they didn't want to be in the situation of trying to say you could have a 5-foot by 6-foot blanket, but not an 8-foot by 10-foot tarp. That these kinds of decisions shouldn't be left to the court based upon the Eighth Amendment. These sort of differences of when conduct is so closely linked to the status of homelessness that it must be permitted. One other example, people said that if it's too far, you don't have to go to an available homeless shelter if it's 30 miles away. But if there's one that's close by and they won't take your dog, you don't have the right to do that. So all these kinds of application questions of when conduct is linked to a status, it is problematic. But I do think at the bottom, I think even a majority of the court will not disturb a notion and may even support the notion that punishing someone based upon the mere status of being homeless it does violate the Constitution, but the question is, what's the remedy?
There was a lot of questioning from the conservatives again, especially the chief. I remember one exchange he had about if there's a shelter to go to over the county line or whatever, do they have to go to that shelter or not?
Right. The question really is twofold, because in that issue, many of the justices think that a town cannot shift responsibility to a different town. That there's something wrong with a city saying, well, that's another city's problem. And obviously, Justice Sotomayor said, well, if all cities take that position, we're never going to have any kind of relief for the homeless. But based upon further questioning, I think the attorneys, even for the homeless coalition, seem to say if there was a close-by shelter across a town's lines, not at state lines, but across the town's lines, that it would be sufficient to offer them, the homeless, a position in a nearby shelter, even across some kind of municipal boundaries. But again, the kind of line drawing that this case raises, I think, has given the court a great deal of pause, and they want to try to give a solution that's not heartless, but nonetheless does not enmesh the court in these very messy details of how best to effectuate a ban on some kind of homelessness that is plaguing many of our towns, across the country.
Does this statute criminalize being homeless?
It does, somewhat indirectly after several civil citations. Then under this ordinance, someone is subject to a criminal violation, and indeed the civil penalties are something like $300 for the first violation, so it's very steep. So there was questions about even whether this would violate the excessive fines part of the Eighth Amendment, but the court below did not answer that, and so the parties did not urge the court to reach that issue at this particular time. But I think even our lawyer for the grants passed the town agreed that under the ordinance as applied, criminal penalties were available.
There was talk about, the danger of having people sleep outside. And when the Supreme Court addressed homelessness the last time, it upheld a National Park Service rule that prohibited sleeping in parks around Washington?
Correct.
So might they say, well, laws like this are to protect the health and safety of the community?
It's true that the best solution is not to allow homelessness. It's to give and create work, enough free food, enough options so that there isn't homelessness. And I think everybody in the court would want to see that for that to happen. But in this case, I don't think the National Park Service precedent really covers this instance, because as the court, everybody agreed there could be like a time, place, and manner restrictions on public camping, when you can go, when you can public camp, and where you can public camp, and whether you can leave items or even cooking gear at your camp. Everybody seemed to think that would be, appropriate. At a minimum, that would be appropriate. But the real question is, at the end of the day, is can you criminalize people who don't have a home for living in the public when, as the justices said, you have to breathe, you have to sleep somewhere. That's part of being alive, and if you don't, you're not alive. And so with that kind of status, or that kind of incredible importance, I think the court must recognize that, even if it tries to get out of the difficult position it has found itself in trying to make these very tough lines that it doesn't feel qualified to make.
So you think that all the justices, or nearly all the justices, would be against criminalizing homelessness, and then there might be splits from that point?
That is my sense. It's obviously difficult, but I think the court was so interested in ways to try to avoid deciding this case. And we talked about 3 earlier, that what's motivating them is the difficulty of trying to say it's constitutional to ban homelessness. And I think that they would be disingenuous if they held that without overturning that 62-year-old Robinson decision. And all of the lawyers told the court, we don't want to overturn Robinson. And if all the lawyers are saying don't overturn Robinson, that puts even more pressure on the court. And I think Chief Justice Roberts tried to say Robinson is different. I think that's incredibly disingenuous. I think this is a stronger case than Robinson because, again, in Robinson, we're talking about the status of something being addicted to drugs. And, obviously there was a criminal offense that led up to that. In this case, it's like, a ban on having COVID or a ban on breathing and so the ban on homelessness itself, I think, is much more difficult to accept even than the ban on being the status of a drug addict in Robinson. So if Robinson stands, I think the court either is going to be disingenuous, which of course has happened, or it's going to try to find a way to get out of this case without having to make a pronouncement.
Is the Ninth Circuit the only circuit that has taken up this issue?
To my knowledge, the Ninth Circuit has taken it up twice, and I do think there's many cases that are now percolating in other circuits that just haven't become final yet because the more recent case has signaled to housing coalitions elsewhere that it's appropriate and indeed wise to challenge any kind of criminalization of the homelessness. And these cases have first started percolating, I think, since the early 2000s in the Los Angeles case. And obviously California and the West Coast has seen some of the worst of public camping. But obviously it's not only in California, and there's a lot of people who camp on the streets in public spaces, all over the country. So this case, I think, is important. It should take a lot of eyeballs across the country. And I think the court's going to wrestle with what to do, again, simply because at the end of the day, I don't think they want to write an opinion that says it's consistent with the Constitution to criminalize homelessness.
Speaking of eyeballs and importance, this week alone, you have this case. You have the case on the Idaho abortion ban. You have the Trump presidential immunity case. Does it seem like the court is tackling more controversial issues this term than before?
It's hard to catalog and making a comparison from term to term. And indeed, I don't think anybody would have known at the beginning of the term. You certainly wouldn't have known about the presidential immunity issue the court now must wrestle with. And I think the Idaho care case, similarly, one wouldn't have predicted a year ago that would be before the court. So some of this has come because of late-breaking developments, due in no small part to the Supreme Court's own actions, but nonetheless, it has become much more of a controversial, hotly contested docket.
It's going to be a very, very interesting week. Thanks so much, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.